Spectacular Dean Petrov, esteemed participants at the conference, dear colleagues. I am honored to welcome you at the Faculty of Law, University of Belgrade. On behalf of Serbian Fiscal Society, the National IFA branch, at the beginning of this major event, International Fiscal Association Central and Eastern Europe Tax Conference. The participants from Austria, Bosnia and Herzegovina, Bulgaria, Canada, Croatia, Czech Republic, Hungary, Italy, Netherlands, Poland, Romania, Serbia, and Switzerland, maybe I missed some country, gathered in this conference hall to discuss today and tomorrow a number of tax issues relevant not only for CEE countries, but for almost all tax jurisdictions in the world. We're happy to host IFA Traveling Lecturing Program this year again, and to be able to combine it with 4 expert panels, and we are grateful to Central IFA for their support in organizing this entire event. In 2018, Serbian Fiscal Society commemorates its 12th anniversary, and I'm proud to say that at the moment we have 137 members, tax advisors, attorneys, academics, and civil servants from the Ministry of Finance and Tax Administration. Since Serbia is a small country, we are pleased to have so significant and devoted membership. Our objective is to promote the tax profession in this country and to facilitate the contacts between our members and the members of other IFA branches. Such a large number of you here today confirms that Serbian Fiscal Society is quite successful in fulfilling its mission. In our activities from the very beginning, we have enjoyed support of the Faculty of Law, University of Belgrade, who is a co-organizer of this conference. Grateful for that selfish backing, I now give floor to its Dean, Professor Dr. Danon Petrov.
Maybe I should stay. Professor Popovic, all the participants of this very specific and very special conference, I want to thank you for the opportunity to welcome you at the Law Faculty of Belgrade. As many of you know, the Law Faculty of Belgrade is a really important institution of the legal education in Serbia and in the region. And during the 1 year of the life of our faculty, we have really a lot of opportunities to organize different conferences about law and other topics which are related to law. These conferences give us experience and give us authority to make other conferences. This conference is very important and very specific related to topic and related to participants of the conference. It is also very important because all those conferences which include relationships between and communication between academic staff, experts and practitioners are the most important conferences. So once again, I wish you a pleasant stay at the Law Faculty of Belgrade, and I wish you fruitful work. Let the conference begin.
Thank you.
As the chair of the organizing committee of this conference, I have to share a few things with you. Until yesterday at around 11 o'clock in the morning, I was thinking that all those people who told me that I was going to curse the day when I took upon myself to organize the conference, I thought they were wrong, and because everything went smoothly, and then at around 11 the hotel called and said they had a plumbing issue and that half of the speakers are going to be moved to a different hotel, so it can be a little bit stressful. But I wanted to share this with you. It's been a joy and a pleasure to organize this, both with respect because we had such support from Central IFA, from our IFA community. At this conference we have presidents of at least 5 IFA branches, so Romania, Czech Republic, Bulgaria, Hungary. We have the General Secretary of the Polish IFA branch. So this truly says a lot about our community, and I would like to, first of all, give credit to people whose idea it was that we should realize that even though we have some virtues in our region, we have some faults, and one of them is that we don't know each other. And I here commend Professor Radu Bufan from Romania, who's here with us, and Professor Daniel Deák from Hungary, who's not here with us, because several years ago they came up with the idea of the Central and Eastern European Tax Lab, and they said we need a platform where people from this region, which share so much and are not aware of it, should meet and should discuss. And the Romanian IFA branch was responsible for several years of organizing this event. This year it is the privilege of the Serbian IFA branch and of Belgrade to host our Central and Eastern European gathering. Also, I would like to thank Central IFA, who from last year, and particularly Brian Schneiderman, he's not here with us today. He will come later on. He had a problem with his flight, but another of Murphy's Law effect, where Central IFA decided to support our region with a Traveling Lectureship Program. We had it last year in, I think it was 9 capital cities in Central and Eastern Europe. This year it's Belgrade, and we have Professor Danon with us. Professor Danon is an esteemed professor from the University of Lausanne in Switzerland. A world reputable name. He's also the chairman of IFA's Permanent Scientific Committee. So basically, we are really being supported by our organization. I think this also shows the importance of being part of the International Fiscal Association as such. We devised a program which has in addition to Professor Danon's lecture, who will deal with probably the most acute topic in our tax world today with respect to anti-abuse and the MLI. We'll have 4 panels. The one today will deal with taxpayers' rights. Tomorrow we will have 3 panels, one dealing with the digitalization of the VAT process. We'll have one on transfer pricing, and finally we will have one on behavioral economics and tax morale. Finally, we will close the conference, because I think this is also very important. We will close the conference with a book promotion. Here with us we have Stjepan Gađo from the University of Rijeka in Croatia, whose book was published by the IBFD this year. It's based on his doctoral research, which has been widely acclaimed, and he received a lot of prizes for it from the European Commission, from the European Association of Tax Law Professors. So we want to show that our region has a lot to offer, and that it's really not good that we are not aware of what all the potential that lies in it. Furthermore, in line with this, with the IFA approach of being a platform where a neutral platform, this conference is we will have both on the panels but also in the audience representatives from all sectors of the tax profession, which are all welcome under our IFA umbrella. So not only tax practitioners and academics, but also we have a large representation from the tax administration, and we also have some representatives from judiciaries in our region. And this is the final word, because speeches should be short. Belgrade is definitely not the most relevant tax place on the planet. Serbia is not the biggest country in the world. That's true. There's one thing that I think we are proud of, and this is what we want to share, and this is our sense of community. The tax community here, the room that you see here, this is filled every month. We discuss tax topics. We are all equal under this roof, and this is why we had such a success in these 12 years of building one of the largest, if not the largest, in terms of numbers of branches in this part of the world. So I would like to all of you to, I wish that you can share in this sense of community, that you're welcome here, and that we will have an interesting and fruitful conference where we will learn from each other and meet each other. So thank you very much for coming, and welcome to Belgrade. Thank you. I would like now to ask Professor Danon to take the floor, and I will, since I'm one of the organizers, I'll go sit over there because I need to be mobile.
Thank you very much. I don't know if I need to be mobile. I certainly do. I will stand, I think, regarding this presentation. And first of all, I'd like to thank the organizers also on behalf of IFA Central. I arrived yesterday. I will not unfortunately be able to stay longer than this evening, but during my short stay in Belgrade, I could appreciate the vitality of the Serbian branch, the vitality of the organizers and their eagerness to actually learn more about international tax law, international tax policy. So I think the topic that I've been requested to discuss today is essentially treaty abuse in the post-BEPS world. It's not a new topic, but it's an important topic. And I will try to, take you through the main policy issues at stake, bearing in mind that this is an evolving process, that much is going on at this point in time at the OECD level. And of course, I'm aiming at an interactive discussion, because when you speak about anti-avoidance, it basically, of course, interacts with your local landscape and your local policy. So I would very much appreciate comments relating to the interaction of the new recommendations and the new framework with your policy, and perhaps then we can exchange on that. So my presentation essentially will be dealing with treaty abuse. I think it's nice perhaps to take a step back and to look at treaty abuse before what we call the BEPS initiative. Then I will go on to BEPS Action 6, which is the core action item dealing with treaty abuse. Then I will dwell a little bit on the policy choices of Serbia under the multilateral instrument, and then the focus of my presentation will be the principal purpose test. But this is just, an idea for a presentation. So if you want to ask me other questions on BEPS or other action items, how they could interact with Serbia, because Serbia has been quite responsive under the MLI, also in other areas compared to other countries, feel free to do so. Feel free to do so. I mean, I'm welcome to entertain any form of question, even in other areas of the MLI or other action items. And then we'll conclude with a policy outlook. So please feel free to interrupt me when you do have questions, or when you feel that you're dying to ask a question. Just say, I have a question, I want to interrupt you. Okay? So let us take a step back at the evolution of the work, the OECD work on tax treaty abuse. It all started in 1977. You had the OECD commentary. Modestly, in 1977, the OECD introduced a chapter to Article 1 of the OECD commentary, which was called Improper Use of Tax Treaties. And there, modestly, the OECD first tackled the issue of treaty abuse. But in fact, the issue of treaty abuse was addressed and discussed way before the 1977 commentary, typically by the US delegation at the time, and in the 60s it was already raising concern about treaty abuse. In our own country, in my own country, Switzerland, we adopted in the 60s a decree. We were pressurized by the Kennedy administration to adopt a decree, which was basically a limitation on benefit, a unilateral limitation on benefit provision, designed to make sure that Swiss entities receiving Swiss source income would not be used for treaty shopping. So you see that the idea of preventing treaty abuse was already there in the 60s, but it emerged gradually into the OECD commentary. So what does the OECD says in 1977? It says, well, basically, treaty shopping is not good, but states have to deal with it with specific provisions. They have to include specific provisions. If they do not, it's too bad. And at the same time, the 1977 commentary does two other things. It first says, well, what is treaty shopping? Treaty shopping is essentially routing income through a jurisdiction in order to take advantage of a double taxation treaty, which would not be available because the investor is actually not in this country. So treaty shopping, the 1977 commentary says, is basically using artificial structures. This is the commentary on Article 1. And then in 1977, there is also the introduction in the OECD commentary of the beneficial ownership requirement. This is a requirement that has been given a lot of attention, and basically there are always two types of schools. One is to construe the term in a very narrow fashion, excluding agents and nominees. Another one is actually also to include it, to discuss it in a more broader fashion. I'll come back to it. In 1986, the OECD issues the Conduit Report. The Conduit Report is essentially sets the scene and says, well, you know, what is treaty shopping? What are conduit companies? What are the strategies that are problematic? But the findings of the 1986 Conduit Report are not introduced in the commentary in 1986. In 1992, the OECD gradually moves in the direction of accepting that substance over form approach is to some extent compatible with tax treaties. You have this finding clearly stated in the area of international hiring of labor, commentary to Article 15. So there you see some evolution already in 1982, also around the idea that the substance over form approach may be applied even in the absence of a specific treaty provision. At that time, there was a division between the OECD member state, but the 1992 commentary says, well, there is a prevailing thought that you can apply the doctrine of substance over form even if there is no express provision in the treaty. This is it gradually evolves, but you can see that it's an ongoing process. It's an ongoing process. It still needed to be consolidated at the time, but you can see it already appearing in 1982. In 2003, we really have a breakthrough. In 2003, the OECD is basically setting the scene and adopting an update to a very controversial update, by the way, to the OECD commentary, which in fact is, the predecessor, and is important from that perspective, is a predecessor of what we have today with the MLI and the principal purpose test. What does the 2003 commentary say? It says, well, states can apply their domestic anti-avoidance rules to tax treaties. There is no conflict as a matter of principle. Secondly, we will adopt what we call a guiding principle. Okay? There is a guiding principle to which I will come back, which is the ancestor of the principal purpose test. And this guiding principle basically says, well, there is a guiding principle in tax treaties that allows you to deny treaty benefit. It's basically a GAR. And how can you operate that GAR? Well, there are basically two ways of doing it. One is to apply your domestic anti-avoidance rule and to say, well, to the extent that the domestic anti-avoidance rule fits with this guiding principle, which is basically a main purpose test, I'll come back to it, then there is no conflict. So the OECD is setting in the commentary a standard for applying GARs to tax treaties, whether these GARs have a treaty foundation, Article 26 of the Vienna Convention, the Law of Treaties, or a domestic foundation. But the findings of the 2003 commentary are very much fragile. They're fragile, why? Because there was always a tension between domestic anti-avoidance rules and tax treaties. And also the idea, the nature of this guiding principle was a bit fragile as well, because we didn't know whether it was a limitation or if it was a standalone GAR. So the appetite to apply GARs to tax treaties clearly emerged in 2003, but the foundation of this reasoning was very much fragile. And this, as I will demonstrate later on, led the OECD to basically solve the problem by saying, well, it's easy. Let's put the GAR into the treaty. And that way it solved the problem. Another breakthrough of the 2003 commentary, it's very much to stretch the interpretation of the beneficial ownership requirement. Before 2003, there was a controversy as to whether beneficial ownership should be construed in a legal fashion, excluding agent or nominees, or in a broad economic fashion, allowing treaty benefits to be denied more broadly to conduit entities. The 2003 commentary basically extends the meaning of the beneficial ownership requirement, giving member states, OECD member states, a tool to use beneficial ownership to strike down conduit companies. And what the 2003 commentary says, well, let's go back to the findings of the conduit report back in 1986, and let's introduce these findings into the 2003 commentary. So in 2003, I would say we'd had a quite powerful commentary to fight treaty abuse, clearly saying, although in a fragile fashion, that GARs and tax treaties are fine, and boosting the interpretation of beneficial ownership quite extensively. Then, and this is interesting, 2014 update of the OECD commentary, and this is a phenomenon that happens often at the OECD level. It's basically changes of trends and reconsiderations. Well, the 2014 commentary is interesting, particularly with respect to the beneficial ownership requirement. As I said, in 2003, the OECD has said, you can tackle anti-avoidance structures, you can tackle conduit structures with the beneficial ownership requirement using a very broad interpretation. Now, between 2003 and 2014, several courts had actually construed beneficial ownership in a very wide fashion. And concerns have been expressed at that time that this interpretation was too broad and could lead to unintended results. So what happens in 2014? The OECD again, I'll come back to it, reduces the scope of the beneficial ownership requirement, bringing it closer to what it was initially, namely a test only focusing on agent and nominees. So the 2014 commentary essentially deprives the beneficial ownership requirement from its extended scope. And at the end of the 2014 commentary, as from the 2014 commentary, the main tool to fight treaty abuse is essentially GARs, because the beneficial ownership requirement and special provision, of course, has reduced in scope. So you see that there is a trend since 1977 towards clearly addressing the improper use of tax treaties, but that this trend may be broken down into several steps. The first step was recognition of the problem, but saying to states you basically have to address it yourself. The second trend was to try to allow the application of general anti-avoidance rules to tax treaties, whether these rules have a treaty foundation or a domestic foundation. This is 2003. And then third element, dealing with the beneficial ownership requirement in somehow an inconsistent way. First of all, extending the scope of the requirement, and then finally reducing it. So now is a good time basically to ask, what is tax treaty abuse? So you can, as I said, we have clear language in the 1977 commentary saying that treaty abuse is essentially using artificial legal construction. When you think about treaty abuse, you're basically thinking about a situation in which a resident would invest in the source state and would not be entitled to treaty benefits with this source state if that resident had invested directly. So that resident is basically using an intermediary state in which an entity is interposed to take advantage of the treaty benefits, typically a reduction of the withholding tax on dividend, interest, and royalties that would not have been involved directly. From a policy perspective, treaty abuse is often seen as a foreign investor investing in a country via an intermediary jurisdiction. So it's basically foreign direct investment in the country. However, there are other forms of treaty abuse which are not discussed in the commentary extensively, but nevertheless the commentary mentions that, or does not exclude that. You see, if you look at the definition of treaty abuse mentioned in the commentary, it says, if a person, whether or not a resident of a contracting state. Now, as I said, the classical form of treaty abuse is the case in which you have a resident of a foreign country investing in the source state via an intermediary state. However, you can also have treaty abuse in what we call round-tripping structures. Think about the situation in which you have investors in the source state that are basically creating an entity in a foreign jurisdiction to basically channel the income they derive from the source state to the intermediary state, and then bringing back the income into the jurisdiction. So treaty abuse, has two forms essentially. The one in which it involves foreign investors, but you can also have domestic investors, typically in a round-tripping scenario. Further to the, and this might seem a bit basic, but I'm just mentioning it quickly so that, because these are concepts I'll use later on. Further to the 1986 Conduit reports, it's basically clear that there are two main fact patterns dealing with treaty abuse. The first situation is what we call the direct conduit structure. This is a situation in which you have an interposed company in the state of residence that receives dividends from the source state, for example, and redistributes these dividends to a resident of a third state who would not be entitled to treaty benefits in the first place. These direct conduit structures are perhaps difficult to address from under the current language of the OECD commentary, at least under the beneficial ownership requirement, because if you receive a dividend and you distribute a dividend to a resident of a third state, the question often that arises is, to what extent are you the beneficial owner of that income or not? In Canada, for example, there is the famous Prévost decision, which said, if a company receives a dividend and distributes a dividend up the chain, why should it not be the beneficial owner? So typically this is a tension for holding companies. When can you say you are the beneficial owner? How long must you keep the income you receive? What are the functions that you must exercise to qualify for treaty benefits under the various standards? And then you have the more easy fact pattern to address, which is the stepping stone case. This is a case in which you have basically a back-to-back or typically base eroding payments. The intermediary company in the resident state receives dividends or interest and pays these dividends or interest in the form of base eroding payment, that is through deductible expense. The common point between the two fact patterns is the fact that the entity in the intermediary state is actually used to channel income to a resident of a third state. So you see in this example that the state which is harmed is, of course, the source state. And then you have another form of, I can just go one more, yes. And then you have another form of treaty shopping, which is what I call abusive restructuring. This is what I call last-minute planning. You transfer shares to a resident of a country simply to avail of the benefits of the double taxation treaty. Now, if you look at the OECD Model Tax Convention, you see, for example, that with respect to dividends, you have the meaning of the notion of dividends being paid. So the material time for the dividend article to apply is at the time the payment is made. So what you can do is you transfer the income to an intermediary state and to a resident company, and shortly after you make the dividend distribution. Question, is that abusive? Is that abusive because the earnings have been generated at the time at which the shares were not owned by a resident, and you just transfer the shares to a resident just shortly before making the dividend distribution? The other form of abusive restructuring is what we call rule shopping. Suppose you have an individual in the resident state. He owns a company in the source state. He would normally be entitled to a 15% residual withholding tax on dividends. He's not happy about this. So basically what he does, he transfers his shares to a company in the state of residence, in the same state. And because of that, he switches from a portfolio investment to a qualifying investment. So it becomes 15-5. Everything stays in the same state, but you improve the residual rates. So the question is, how should the source state react on this? How should the source state react on this? Should it accept basically that, it was initially a 15%, and just should it accept the transfer to a company at the last minute just to move from a portfolio investment with residual rates to a qualifying rate? But the issue is the same. The state of source is harmed. So what are the policy issues at stake? The policy issues at stake have been consistently reiterated by the OECD. Typically, treaty shopping poses a problem because you basically extend the scope of a bilateral treaty to a resident of a third state. So it basically becomes a treaty with the world. I try at times to explain treaty shopping to my students in Lausanne by making an illustration which basically involves my son. Well, it's basically the following. Suppose that I prepare, and by the way, I do prepare very nice food for my son when he goes to school, because I know that at 10 o'clock he will have his break. That's why, I prepare very nice food. I prepare this, by the way, quite busy, but I prepare this for him every morning. And suppose that I prepare this with all my heart in the morning, and then at 10, when he takes his break, he goes with his classmates, and the first thing he does, he gives what I've prepared for him to his friends. I'm not happy. As a father, I'm not happy, because that was just for him. It was a privileged thing that I did for him before going to work. And believe me, it's a lot of work for me, because I'm not very good at that, but I'm trying my best. And the first thing he does, he gives it to his, to his classmates. But it's exactly the same with treaty shopping. The source state is actually giving an advantage to the resident state, and the first thing that happens is that this advantage is basically extended to a person that, the source state doesn't wish to enter. It's not me, huh? I feel innocent of all charges. Oh well, I didn't mean that either, but anyway. So the thing is, the source state is basically forced to extend, let's say, the treaty benefits to states with which he didn't want to extend such treaty benefits. It's the same with my son. I'm giving him something, and this is being extended to his classmates. I'm not happy. The source state is not happy. And one issue which will be discussed also from a policy perspective is if you have treaty abuse, because there are numbers of treaties, so if you move from a less favorable treaty to a more favorable treaty, should you accept the idea that if there is treaty abuse, the source state should at least give the benefits that it would have granted had the original treaty being applied? This is also a question that we'll be addressing. So what you have to keep in mind for the time being is that treaty abuse affects the source state. But then there is, then there is another question which I would like to address, because we say treaty abuse affects the source state. Essentially, treaty abuse forces the source state to reduce withholding tax on dividends in a way not intended. Now, I have a policy question for you, and I would pretty much engage into that debate. Is treaty abuse bad? You think it's bad? Suppose, for example, that Belgium enters into a treaty with Hong Kong, okay? And the idea of this treaty is basically to allow foreign investors to use the treaty with Hong Kong to invest into Belgium. Now, suppose that India has a treaty with Mauritius, and the purpose of this treaty is to allow investors, foreign investors, to basically invest into India in a tax-efficient way. And suppose that this company is incorporated in Mauritius, lacks substance. They don't have much substance. We know it, they know it, everybody knows it, but it's tolerated because it's a good way of having foreign investors investing into the source state. So they allow it. And that's what was discussed at some point in India in the Azadi Bachchan case. Well, the court said in that case, well, you know, to some extent treaty shopping is very much like a subsidy or an incentive. It's basically something that is used to attract foreign enterprise and offshore activities. Allowing entities, allowing foreign investors to invest into the country using a particular route which is known to some extent as actually jeopardizing the effect of the tax treaty, or, you know, allowing for a very liberal application of the tax treaty. And then the sole state says, well, I know that I'm giving up my taxing rights because the treaty is applied in a very liberal fashion, but at the same time I get, you know, investment into my own jurisdiction. So the question is treaty abuse bad? But the same court, and that's where you see the policy discussion and the policy distinction in India, said, well, you know, we can accept that foreign enterprise invests into the country and that we use a particular treaty, for example, Mauritius, to have some sort of incentive to invest into the country, but what we cannot accept is circular trading, round tripping. If we have Indian investors using Mauritius to basically escape or erode the Indian tax base and then route back the income into the country, we're not happy. We're not happy because we don't get any benefits. The end result for us is just stripping our domestic tax base, and we don't get any benefit in return. Whereas with foreign direct investors, we say, okay, we reduce our taxing rights, we know the treaty is applied in a liberal fashion, but at the same time, we attract foreign investors. So at some point in time, there is, you know, it's an arbitrage. We get something in return. And this is basically one item that I want to raise, because it will be also important when we discuss the PPT and the changes to the preamble of the OECD Model Tax Convention, is, can you say that there is a unified and standard purpose of double taxation convention? Can you really say this? That's an important point. I mean, there is, of course, the academic view, the principal view of saying, well, double taxation treaties should be used to foster and promote investments and exchange of goods and services, blah, 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 between the contracting states. We know this language. Now, if you have income being transferred to the state of residence, from the state of source to the state of residence, and in the state of residence there's just a shelf company with no functions, no employees, nothing, and this income is basically just transiting to a third country, you can hardly argue that there is an actual exchange of goods, of services between the two contracting states. So from that perspective, you can say, well, you know, the purpose of the treaty is not fulfilled. But at the same time, if you get side benefits, I mean, if this is a way of attracting foreign residents, foreign investors into the country. So the question I would like to ask you is, do you think there is a uniform purpose of double taxation convention? Do you think that all treaties should always be used to foster trade investment, or that you could make some compromises depending on the side benefits you get? I mean, or is it something that should be negotiated and agreed upon with every treaty partner on a on a case-by-case basis? What do you think? Would you accept treaty shopping if it promotes the investment into the country, or would you never accept treaty shopping? You want to cast a vote?
Yeah, I think a vote would be nice.
Yeah.
Yes.
This is a good way of me taking a break.
Plus, before we take a break, I think it's interesting because we have here in this country at least two experiences which show that the actual investment value of double tax treaties is highly questionable. Two countries which were our major investment partners from 2001, with Greece and Austria, during the highest investment activity from these two countries, we didn't have double tax treaties. It was actually after double tax treaties were enforced that actually the investment activity didn't change that much. There was not that much effect. So, and I think there are serious econometric analysis being done in the UK and at the University of Oxford, which actually doubt that double tax treaties actually do anything with respect to foreign direct investment, and that it is, and if you have, to quote David Rosenblum, he calls them just a badge of international tax respectability. That having a double tax treaty actually shows other governments that you're a their investors, that the government thinks you're a jurisdiction that business can be done with. And I think it's a good also analogy during the communist times. Several countries, and I think North Korea still does it, even though their system is such that you don't need a double tax treaty with them, they like signing them because it gives them international political recognition.
Serbia does have.
We have a treaty with North Korea, and many other countries do, but there's no point in it because we do no business with them.
Do these treaties make harm?
No.
Good.
No.
Good to know.
Not really, but it's and I think economically it's very questionable what the effective value is. In some cases there is value, but in some cases we can show that nothing has changed. So,
But no harm is done.
no. So on this note, let's do a vote. Who thinks double? Would you like?
Let me perhaps restate the question. I'm not asking a question on whether tax treaties are being effective. I'm just asking the question on if there is clearly treaty abuse, would you still allow the application of the treaty because it still provides, certain other benefits like attracting investors?
Let's vote.
Let's vote. Who thinks yes?
Yes, of course.
So you would allow the application of the treaty? Yeah. Who thinks no?
Good to know.
Very interesting, very interesting, very interesting, very interesting.
Tusmane.
I mean, why I'm raising the question is because in the past you had a quite neutral preamble to tax treaties, but now with the BEPS framework and the minimum standards, you have to include, and Serbia has included, a statement in your tax treaty, a new preamble, which, as you will see, is saying that tax treaties should not be used for treaty shopping, and there is no carve out for foreign direct investors saying this. Hey, by the way, treaty shopping is good if it's only if it allows you to have foreign investors. So. The policy question is there, unifying an understanding notion of what is good and what is bad when it comes to treaty negotiation? And I think this is good to keep in mind when we'll be discussing the principal purpose test and the BEPS framework. So let me perhaps now go to BEPS Action 6, the MLI. So first of all, I don't have time to discuss at length the
Professor Danon, sorry.
Yes.
Just I think just to come back on your point, I would like to hear your, with respect to discussed, would it make sense to answer to this by first of all asking whether, for example, Serbia is a capital importer or a capital exporter? I think that would be the underlying question, at least I would say, in the perspective of Italian tax treaty negotiation, for example. The first question that we always asked was, okay, my treaty partner, is it vis-a-vis my economic objective, is it a capital importer or capital exporter? Because obviously that would steer the question that you rightly posed. It seems to me that now the position that the OECD has taken in modifying the terms of the preamble is saying, I don't care any longer about this underlying economic consideration. I just want to try to tighten, the borders.
Yeah.
So I would like to know your view if this is still relevant or not.
No, I think that the question you're asking is basically interesting for several reasons. The first reason is indeed when you negotiate a treaty, you cannot actually negotiate treaties in the same fashion depending on whether you're a capital import or capital export country. If you look at a very basic provision in the treaty, is Article 23A and B. If I am Switzerland, I have capital import neutrality, so I have an exemption method. If I am a capital export neutrality country, I would have the credit method. So of course, these considerations are highly important. But my point was perhaps beyond that, in the sense of saying, well, is there a common understanding that treaties should, only be used within a certain range? And is there an international unified notion of what constitutes improper use of tax treaties? And when you look at the country's policies, you've seen that countries have been balancing, on the one hand, the improper use of tax treaties with other considerations. But when you look at the new preamble, of course, this, in my opinion, will no longer be possible, because there is one notion of what constitutes treaty abuse, basically completely ignoring other policy consideration. So I'm not saying that treaties should be used for treaty shopping. I'm not saying that treaty shopping is good. I'm just saying that not all countries have the same policy.
And just one small, I think that since I think most of these, most of what the OECD and most of the anti-abuse story, if you look at especially the LOBs, now we've been obsessed with companies, right? It is the abuse that's been done through some form of incorporated structures. And I think perhaps maybe the debate will start changing when we look at the fact that at this moment, there I think 57 countries are actually listed as selling residents.
Yeah.
So now you have, and in Europe, it's at least 20. From Portugal, who does it for 350,000 euros investment and 2-week stay. Latvia, 35,000. Italy is now selling residents. The UK has done it always. Malta, Cyprus, France, but it's very expensive. But in any case, now that we're seeing is that we've taken individuals for granted, residence, citizenship, nationality, various factors. We've never questioned them. Now that this becomes a traded commodity, just as corporate residence, then I think we might start seeing a more integrated and coherent approach, because I think a lot of this is basically just a panic reaction. Because when you look at rightly the Indian case law that you've noted, it's okay if others abuse the treaty, because why should I care? I gave it anyhow. I don't like my residents abusing my tax law by channeling investment not directly but through an offshore jurisdiction. And then let's close it all. But this is okay, but then I think that we are doing it the wrong way, because I think we're trying to fix the loophole by either putting something in a preamble which
usually nobody reads, or by, now we'll have to, because we're told we should, or by putting in such broad rules that we don't really know what their full impact is. And I think it smells of a panic reaction.
Yeah, it
Thank
smells
you.
of a panic reaction. Also, another point that I will be addressing is that you have to keep in mind, although I don't have the time to address this, that the whole BEPS initiative is driven by, supposed to be driven by common principles, typically substance, coherence and transparency, and around substance, value creation. And of course, this principle, which is very interesting to discuss, and we've been discussing, by the way, at the 80th anniversary of the International Fiscal Association back in May, has been given a different meaning, whether it's from a treaty perspective, from a transfer pricing perspective. What is the meaning of artificiality? What is the level of nexus that you require for a given state? You know, what is the sustainability of the arm's length principle in the post-BEPS rule, etc. Anyway, I come back to the core of the discussion. So the minimum standards are the amendments of the preamble to tax treaties. This looks very much, as you said, as a statement that one would not read at the beginning. However, it's interesting when we'll be discussing the principal purpose test to note that most of the examples in the commentaries refer back to the preamble of the tax treaties, the new preamble. And this actually raises another issue to which we will come back, which is the one of tax certainty, because the principal purpose test raises a lot of issues in terms of predictability and tax certainty, and this is why the latest update of the on the tax certainty report has indicated that the working group at the OECD should be providing guidance on how to apply the new treaty GAR. But I will come back to this. So on the one hand, you have the minimum standards, which is the amendment to the preamble of tax treaties, the inclusion of a principal purpose test, and you also have the possibilities for states which do not want to have a principal purpose test to basically apply a detailed LOB coupled with an anti-conduit rule. But what you can see is the principal purpose test is the only test which basically meets the minimum standard on its own. And then you have a series of recommendations that states may wish to include, typically provisions targeting some form of treaty abuse, typically treaty SARS, dealing with dividend transfer transaction. This is a provision dealing with abusive restructuring. If you transfer shares to a resident company shortly before a dividend distribution, the dividend transfer transaction would be taking care of this. Boosting a little bit the provision on capital gains in real estate companies. Anti-avoidance rules for PEs in third jurisdiction. This is more for countries which have an exemption system. And finally, the savings clause. Now, if you look at the policy of Serbia, the policy choices of Serbia, clearly Serbia has opted for the PPT, no choice, include the amendment to the preamble, and also certain treaty SARs. Now, coming back to the core of my analysis, typically the principal purpose test, we have until 11, is that correct?
Yes.
Okay, so that's... so let me perhaps come back to the origin and the present and the presentation of the principal purpose test. Well, there is a saying at the OECD in the sense that there is nothing really new in treaty policy. It's basically actualizing, refining earlier work. And that is basically true with respect to the principal purpose test, because remember I mentioned that in 2003 the commentary was boosted by the inclusion in the commentary of a guiding principle, which was basically a treaty GAR being included in the commentary. Now in 2003 you had this GAR principle that was included in the commentary, and if you look at the language of this provision, it's very much similar, if not identical, to the language that you have today with the principal purpose test. The difference is that, of course, it was included in the commentary. The second difference was that the foundation of the guiding principle was unclear. Was it just a standard limitation to basically make sure that domestic anti-avoidance rule would not go beyond the guiding principle, or was it a GAR of its own? That was controversial in 2003. In 2017, the OECD basically moves the guiding principle into the OECD model at Article 29, paragraph 9, with some distinctions. Well, you see, the new GAR is a bit more elaborated on several points. First of all, it is articulated as a typical GAR in the sense that the tax authorities have the possibility to deny treaty benefits if it's reasonable to conclude. This is a reasonableness test which you have in all GARs as a matter of principle. And then the taxpayer has the possibility to demonstrate that treaty benefits should nevertheless be granted, because granting these benefits would be in accordance with the object and purpose of the relevant provision. Sorry, provision is missing here. Well, it's good that I omitted in accordance with the object and the purpose of the relevant provision. Why is it good? Because, as I said, when you look at the commentaries are basically saying, well, the extent to which the taxpayer is able to demonstrate that granting the benefit of the tax treaty would be in accordance with the relevant provision of the convention basically amounts to looking at the object and purpose of the treaty as a whole in most of the example. Which brings us back to this question that I raised before: what is the object and purpose of the treaty? I'll come back to it. So there are several items that deserve consideration when you look at the principal purpose test. The first, of course, which has been widely recognized, is the fact that the test lowers the abuse threshold, somehow reverses the burden of proof to the detriment of the taxpayer. I mean, these criticisms have been widely articulated. Then the other issue is also the relation between the principal purpose test and specific anti-avoidance rules. Suppose that you have a specific anti-avoidance rule in the treaty. Can you still apply the principal purpose test to the same fact pattern covered by the specific anti-avoidance rule? So suppose, for example, that you have a specific anti-avoidance rule that says, well, treaty benefit should be granted because the taxpayer does not meet the condition of the specific anti-avoidance rule. Can the tax authority revisit the same fact pattern in light of the principal purpose test? Well, this is suggested by the language in the new PPT, saying notwithstanding any provision of a covered tax agreement, notwithstanding any other provision in the convention. I personally take a different view. I argue that this provision should be construed by reference to the facts that it covers, in the sense that the PPT can only apply to elements of facts that are not covered by a specific anti-avoidance rule. So, for example, if you have a provision dealing with a certain fact pattern, and this fact pattern is exhaustively covered by a treaty SAR, the PPT may not revisit the facts that are covered by this treaty SAR. However, the PPT may apply to the elements of the facts that have not been covered by the relevant SAR, which then makes sense to refer to notwithstanding any other provision of the convention. Because if you don't do that, then you inevitably run into a great area of uncertainty. For example, if I come back to the recommendations that you have, it would be absurd, in my opinion, completely absurd, to allow the application of the principal purpose test in a case that is fully covered by the dividend transfer transaction. Because otherwise, why would you have this provision in the treaty? Of course, you may argue that the PPT is a general guard. However, this is a good example because this is a BEPS provision. It has been developed exactly at the same time. So basically, if you say, I can apply the dividend transfer transaction, treaty benefits should be granted based on the dividend transfer transaction, but I may deny treaty benefit based on the principal purpose test, it's exactly like saying, well, there is no difference in including this recommendation. So basically, you're killing the own BEPS star. So you see that the proper delineation between the GAR and the SARs requires one to say that if a provision is covered, if the facts covered by a provision are exhaustively covered by a treaty SARs, the principal purpose test should not apply to these elements of the facts. Otherwise, the treaty SARs, and in particular the BEPS SARs, become completely pointless. Yeah, but I mean, this principle, of course, which you mentioned, which is well known, you could argue, otherwise by saying, the principal purpose test has been included later on in the treaty. But where you see that this principle still stands, it is with respect to treaty SARs that have been adopted and elaborated at the same time as the PPT. So I mean, in the case of Serbia, if you have the dividend transfer transaction provision in the treaty with the other contracting states, I mean, if the taxpayer satisfies the holding period for the dividend transfer transaction, you cannot say, well, sorry, the dividend transfer transaction is the holding period is satisfied, but we will revisit the holding periods based on the principal purpose test. You can challenge other elements of the facts, but not this one, because otherwise it doesn't make any sense to have the dividend transfer transaction, and it's a disincentive to adopt the recommendation that the OECD has itself developed. And you're actually increasing tax uncertainty and diminishing the purpose of these SARs, which is precisely to increase tax certainty. Yeah. Please. I was expecting a comment.
With respect to what you've just said, I would say it's good to have both, the PPT and the special treaty SARs. Why? Because PPT is a minimum standard, and treaty SARs is not. So, with respect to our experience regarding the MLI, many of our treaty partners didn't accept special treaty SARs regarding dividend transaction, but they accepted the PPT. So it gives us, as a source country, right or opportunity to apply PPT, although we don't have special treaty SARs. So it's good to have both.
I fully agree with you. Just to clarify, the point that I was trying to make is the following. The dividend transfer transaction provision says, well, the shares have to be held for a certain amount of time, okay? Let's say 300 days, I don't remember the exact dates, but whatever. And suppose that the taxpayer satisfies the relevant numbers of days. So in that case, you say, well, for this fact, we say we have a long-term shareholding, it's fine. What I'm just saying is that if the treaty says there is a certain amount of days during which you have to hold the shares, then if you hold the shares for this amount of days, you can say that the ownership of these shares is not abusive. So what I'm saying is that you cannot say, if this test is satisfied, that you can apply the PPT to say, no, we want you to hold the shares for 600 days. That's what I say. But however, you can apply the PPT to other components. In that case, I agree that it's good to have both, but they should be properly delineated.
And I think you can make a parallel where I would absolutely agree with the interpretation which you gave. We have in several countries general anti-abuse rules domestic ones. And for example, in this country, we use the economic substance approach. So theoretically, based on just this general provision, we could attempt to deal with transfer pricing. Some other countries have done this.
Yeah.
But we have specific transfer pricing legislation which tells us can you be considered related parties, how do we test the transactions, how do we apply, we introduce the arm's length principle. So in this same situation, we would have a complete analogy. We've said what we think is something that we will accept, and we can use the principal purpose test as a general rule when we have a SAR, only perhaps to dispute the arrangement itself. So we can say, yes, 300 days is valid, but we would dispute the holding itself.
Yeah.
We think that the holding doesn't exist. This could be done, but to dispute that which is in the SAR itself, I think even in a European level, it would be unacceptable from the legal certainty perspective, because then we would have two rules of identical value, because there's no hierarchy effectively, at least not put into law itself, and then we wouldn't, there would be no rule.
Yeah.
There would be a rule which would be meaningless, and this would be a level of uncertainty which at least those who follow the European Convention of Human Rights would be unacceptable.
Yeah.
Thank you.
Yeah. Going on the PPT, the purpose of the PPT, of course, is a treaty GAR, and unlike, for example, the beneficial ownership requirement, it is a rule that applies to all the distributive rules of the treaty. So basically all the distributive rules, not only dividend, interest, and royalties, but all the distributive rules. One question that arises in the application of the PPT is the notion of benefits. The PPT rule basically refers to benefits under this convention. Now, the question that arises is to what extent the PPT could be applicable to deny a benefit that stems from domestic law. Suppose you have, let's say, a situation in which tax treaty benefits involved are completely identical. So, for example, suppose that the source state has concluded a double taxation treaty which provides for equivalent benefits vis-à-vis two resident states. But suppose that the taxpayer changes the residence or transfers shares to the second resident state because the corporate income tax rate is lower in that state. So the source state is not worse off. You have a same residual rate on the relevant treaty income, but the position is improved because you're restructuring your operations so as to take advantage of a more favorable corporate income tax rate. Question is that treaty abuse? What do you think? Just to give you an example, you have a company in the US, for example, that has a subsidiary somewhere in a state which provides for a certain residual rate with a source state, and that company is basically, the subsidiary is being transferred to another state in which the corporate income tax rate is lower. Can the source state say, well, it's treaty abuse? Or would you say, no, it's not treaty abuse because treaty benefits have not been increased? Does the mere fact of improving, of going to a jurisdiction simply because you have a lower corporate income tax rate, although you're not improving tax treaty benefits, does this lead to treaty abuse? Well, there are basically two ways of looking at it. A first way is to say, well, the PPT should not apply because there is no increase in tax treaty benefits. The state of source is not harmed because the treaties remain identical. That's the first way of saying it. You know, the fact that there is a more favorable corporate income tax rate in the end has nothing to do with the PPT, which is only concerned with treaty benefits. That's one way to look at it. If you take that view, that means that treaty benefits, that the notion of treaty abuse, must always include an increase in tax treaty benefits. In other words, the source state must always be worse off or in a worse situation after the restructuring. That's a first way of looking at it. Then you have another way of looking at it, which is to say, well, okay, the source state is not in a worse situation because initially there was a certain withholding tax rate, and after the restructuring, the new treaty provides for an identical withholding tax rate. So the source state is not in a worse situation. However, you may say, well, but what is the level of nexus that the taxpayer has with the new jurisdiction? Is that sufficient? And in the US, there is a case which is called the Starr case, which involved a situation in which there was a series of migration of a company, first to Ireland, essentially, well, before also, but first to Ireland, and then ultimately to Switzerland. And then, from a treaty perspective, the US was not necessarily in a worse situation after the restructuring, i.e., before the company was in Ireland and then it moved to Switzerland. But when the US was confronted with the discretionary relief provision, which involves a principal purpose test under the Swiss-US double taxation treaty, he says, the US court said, well, sorry, but the fact that I'm not the US in a worse situation is not relevant. What I see here is that the level of nexus with Switzerland is just not enough. So treaty shopping, the US court said, does not necessarily imply that there is an increase in tax treaty benefit. You have to look as to whether you do have sufficient nexus with the new residence state. So it's interesting to see, by the way, the Starr case is quite controversial, but it's quite interesting to see that today one of the leading cases dealing with the principal purpose test under treaties comes from the US, which is a country that is of course opposed to the principal purpose test via the limitation on benefits provision into the Switzerland-US treaty. So this is an open issue that also needs to be will also need to be clarified in the framework of the tax certainty work on the PPT. I'm not going to discuss at length the other items. Just keep in mind that the PPT applies to everything: abusive restructuring, combi structures, and so on. Yes. As I said, the PPT applies if it's potentially applies as soon as it's reasonable to conclude that the objective is to one of the principal purposes of the scheme is to take advantage of the treaty benefits. This raises also some issues with EU law in light of the legal certainty principle. Now, when you look at the examples, as I said in the commentaries, what is really controlling for the principal purpose test analysis is what is the purpose of the treaty. Does a particular arrangement meet the test of the purpose of the treaty? So when you look at the examples in the commentaries, the commentary says, well, to deny treaty benefits, we will deny treaty benefit as soon as it is contrary to the object and purpose of the convention to grant the benefit. So you see that here the commentaries is departing from the actual language of the PPT, which refers to the object and purpose of the provisions, not to the object and purpose of the convention. Why? Because it's virtually impossible to determine what the object and purpose of a particular distributive rule is, apart from, let's say, avoiding double taxation. And that's where it becomes controversial to grant treaty benefits. The commentary says, well, we will grant treaty benefits, or treaty benefits must be granted as soon as the scheme is in line with the fact that the general objective of tax conventions is to encourage cross-border investment. So what the PPT is doing is making a link between granting treaty benefits and at the same time the object of tax convention, which is to encourage cross-border investment. So this is basically moving us back to the previous question which we discussed: is there a unified purpose of double taxation convention? Now the new commentaries seem to assume that this is the case. This is the case in the sense that if there is no cross-border investment, then treaty benefits should not be granted. So everything which we discussed in the sense of using treaties to promote foreign direct investments into a country, while at the same time there's not much happening between the source state and the intermediary state, is no longer possible. There's got to be an exchange of investment between the two contracting states based on, let's say, the language of the commentaries, which is basically elevating the idea that treaties must always lead to an increase in cross-border investment between contracting states, and therefore may not be used to achieve indirectly other objectives, such as stimulating the presence of investors of first state into the source state. Now, the critical issue which will need to be clarified in the work on tax certainty is the importance of substance. That's the critical issue. The OECD has actually already started to go into that direction with the 2017 commentaries. However, there are several open items still in the commentaries which lead to certain uncertainty. I think from the perspective of business, from the perspective of the tax administration, the area of uncertainty lies in the fact that from the perspective of business, it is feared that the application of the PPT might allow tax administration to strike down structures which have valid business purposes. And from the perspective of the tax administration, the concern I hear is practicability. I mean, you need to be able to apply the PPT in a practical fashion. I mean, if you are a tax inspector in charge of the withholding tax division in a country, specifically in a civil law country, you cannot just say, well, you know, is this one of the principal purposes? Now I have the commentaries, but is this one of the principal purposes? What is this stimulating cross-border investment? And there what's interesting is that, of course, there's a way to achieve this. It's the LOB. The LOB, of course, will give you some sort of guidance in this area with the active business test in particular. However, it is not the minimum standard, and it is not the practice of states, all states, to want to have an LOB. So the question is, for states which have the PPT as the minimum standard, how can they find the right balance between having a flexible tool allowing treaty abuse to be tackled, but also having some sort of, predictability? Now, the key issue in this area is the notion of substance. The 2017 updates make reference on a series of occasions to actually cross-references to substance. There is a general statement in the commentaries that says that there is a presumption that treaty abuse will not exist where a particular arrangement is inextricably linked to a core commercial activity. There you see a link also with the agenda in the BEPS initiative, with the value creation, in other words, with the nexus between the income and the activity generating such income. So this is a first indication, but of course, it's very, very, very vague. And then if you look at other examples, the OECD, on a number of occasions, seems to rely on a reasoning basically based on transfer pricing, in the sense that as soon as you have an entity which exercises, I quote, substantive economic function using real assets and assuming real risks, then there is a presumption that the scheme is not abusive. So you do have a cross-reference to transfer pricing. But I mean, it's not well articulated or sufficiently elaborated. But clearly you see a link. Then the question is, of course, can transfer pricing be used as a guidance in this respect? And there it would be interesting to have your thoughts on this. For example, if you take IP income, if a company in the resident state has the relevant DMP functions, owns an intangible from a transfer pricing perspective, would that be a factor that would be relevant to establish that, that treaty benefits should also be granted under the principal purpose test? Then there is, of course, a similar, and this is a cross-reference to BEPS Action 8 to 10. I'm not opening the controversy on BEPS Action 8 to 10, but I'm just opening up the cross-reference with BEPS Action 8 to 10. Then there is another cross-reference, which is BEPS Action 5. Suppose that the source state is paying royalties to an entity in the resident state which takes advantage of the modified nexus approach. So you have the source state that pays income to an entity in the resident state that basically is a patent box, and that income benefits from the modified nexus approach. Can you say in that case that treaty benefits should automatically be granted? I mean, it would be a way of achieving a certain level of certainty, because then the tax administration in the source state could say, well, as soon as income is being paid to an entity which is treated as modified nexus in the other contracting state, then treaty benefits would need to be granted without further analysis. I appreciate that the rationale between BEPS Action 5 is different than BEPS Action 6. However, I also appreciate that they are linked with common principles. Now, if you look at the fact pattern covered by the modified nexus approach, what does it mean? The patent box has been narrowed quite significantly, and what it means essentially is that the income which we benefit from the patent box is typically income that would be linked to in-house R&D, because you know what the patent box, the modified nexus approach does. It basically restricts the benefit to income, subject to small exceptions, but basically restricts the benefit of the scheme to income which has been, generated by in-house R&D by the taxpayer itself. So there you could say that there is a clear link between the income and the R&D activity in the other contracting states. Also, the patent box excludes the cost linked to acquired IP. So it's basically the IP which has been developed by the relevant entity in the resident state. So you have clearly a link between the income and this activity. So from that perspective, you could say, well, how can you have treaty abuse? This would be a way to basically have some sort of certainty, at least with one particular area. But I would like to engage you into this debate. Do you think that there's a link between the PPT and transfer pricing?
I have with respect to your example, one question which I think maybe BEP Action 5 and the modified nexus approach will actually leave open. Because if we would take the unmodified nexus approach, which would say basically whatever is the IP which is effectively created in the resident state should be allowed the beneficial IP box treatment, the lower effective rates, and so forth. But what about the 30% increase that we have in the modified nexus approach? Because that says basically we will not only allow for that which is created, but we will give this 30% increase. And then one could say theoretically, because we still don't have practice in this, well, this is just a rule which says whether or not your IP box is kosher, but that it's okay that you're not skimming off the tax, the income of other countries. But what about the 30%?
Yeah, that's a good point. But I think that if you go into that direction, then you would typically also take the view that if a company, that I'm going back to transfer pricing, but then you would also take the view that a company that exercises a DMP function, that is actually the owner of an IP from a transfer pricing perspective, that would not be enough in terms of link, which would be quite harsh actually if you think about it, because I mean if you look at the DMP functions, you can either exercise these functions by doing the R&D work yourself, or if you can control, if you have sufficient control, you can still outsource. So I think coming back to the modified nexus approach, what the modified nexus approach is doing from a policy perspective is to say, well, it is impossible for any company in the real business world to actually completely do by itself the entire development of an intangible. So from that perspective, we will allow an uplift in relation to outsourcing costs. But that uplift is just 30%. So the essence of, let's say, the activity is still conducted by the taxpayer itself. So I think that provides a good indication that if the income is treated as, because the modified nexus approach is a proportionate approach in the sense that the more activity you get, the more expenses you get, the more R&D expenses you have, the more incentive you get. So basically the income is linked to that activity. So I think that if you would say that you don't have treaty benefits may be denied despite the fact that the income is linked to the activity conducted by the patent box and that it is IP income within the meaning of the patent box, I think that you would, from the PPT point of view, you would place quite a huge amount of requirement as to the nexus of the residency. Yes.
No, I think to answer your question, whether there is a link between principal purpose test and transfer pricing, definitely now the answer after BEPS is yes. And I mean, if you look at the changes to the transfer pricing guidelines, I remember the Working Party 6 struggled to define what substance was, and then there was not consensus, and it came up to refer to capabilities. But I think this is an important question for countries like Serbia. Also, I mean, countries like Italy, we had this very problem, because I believe that such an approach distorts now the fundamental rooting of the arm's length principle, because arm's length principle is not, at least in its creation, a provision that you would serve for tackling abusive structure, so to say, but would be primarily an income allocation rule. So now, for example, if you look at Action 3 on BEPS, I think the OECD contradicts itself, because on the one hand, it refers to the principal purpose test with this clear link, but then it says, I would apply CFC rules only as a backstop to transfer pricing. So only if you transfer
in a cash box, for example,
or in a cash box. So the point is, if I'm designing a tax system, I don't believe, I think there is case law that should tell you, well, I need to use transfer pricing rules to challenge abusive structures, because I should have CFC, I would have abuse of law, principal purpose, and so on. But now it seems that the OECD doesn't care about that and say, look, if I can't get in stopping, let's say, abusive structures with, CFC legislation, or I cannot apply, or interest limitation, then I go to transfer pricing rules. It is clearly a policy choice, but I wonder whether this is a little bit contravening the very same purpose of transfer pricing rules.
I couldn't agree more. I think if you look at the work that the OECD has been conducting since the business restructuring reports, moving from legal interpretation to actual conduct, culminating with BEPS Action 8 to 10, of course, you may wonder, one day we may wake up and say, is this in line with Article 9? I mean, fully agree. But the question is, in terms of certainty, it's a paradox, because I was saying, well, you know, if you have the DMP functions, you should be fine. But, of course, this whole idea of DMP function is already stretching the arm's length principle to some extent. But suppose we wouldn't have this. Don't you think that we would be, from a certainty point of view, in a worse situation? Because, I mean, then if, I don't know to what, when, you know, will treaty benefits be granted? I mean, for the patent box, for example, the patent box, a modified nexus approach, from a conceptual point of view, it's been highly debated whether patent box are good, whether the modified nexus is good, whatever. But the fact remains that the modified nexus approach captures a very specific fact pattern, which is basically in-house R&D. So, if I am told tomorrow as a group that an entity receives IP income as a patent box, and there is no 100% guarantee that that income will benefit treaty benefits because of the PPT, then I think the group will go crazy. Because it's impossible to have a clearer link with the jurisdiction than with the patent box. Yes?
I could agree with colleague that there should be a link between transfer pricing and PPT, but he just reminded me on a concrete problem or situation we are facing nowadays. We are negotiating a treaty with an EU and OECD country. It's an issue of dependent or independent PE agent. Article 5, paragraph 6, a second sentence.
Yeah.
I won't refer to the Germany's reservation, because Germany put a reservation with respect to that concrete proposal. But the question is, suppose that an independent agent did everything under arm's length and doing business with the closely related enterprises, which is defined under the BEPS or the OECD 2017 update. Are we allowed to say that he is not independent agent or yes? Mm-hmm. So formally he's independent. He did everything under arm's length, but there is a fact that he is doing business mostly, we may argue what does it mean, 99%, 95%, with the closely related enterprises. Mm-hmm. So looking at that concrete situation, what we could say, he's independent or dependent.
Yep.
So the problem is then that is our concrete problem. The same EU and OECD country made a reservation with that provision with respect to the MLI, but at the same time was silent regarding the OECD 2017 update. Mm-hmm. And for us, as one of contracting party, it is an unclear situation.
It's very interesting the point which you mentioned, because indeed there is no automatic symmetry between the position expressed by the states under the MLI and the corresponding observation and reservation made under the 2017 updates. That is true. That is true.
In fact, we don't have problem with the reservation of that country regarding the MLI. Our problem is concrete negotiation following the OECD 2017 update, because we saw that the country was silent. Mm-hmm. And the question is a legal dilemma or principle. Does it mean that country agree with OECD principle, with the wording of OECD or not? Mm-hmm. We understood that since there was no objection or observation or even reservation, they agree with that. And we asked our treaty partner, why you are not ready to accept the second sentence in Article 5, paragraph 6?
I don't agree fully with Gianmarco's contention that it is an absolute answer. I think that it is an absolute answer that we are relying on transfer pricing analysis, but that is from a tax professional's perspective. And this is where I'm going to draw a line to. If you look at, so basically you don't have it written down So nobody tells us explicitly that we should do this, but because the body of analysis is there, and because it's so clear, and because it deals with an issue which we can link and which is similar, this is where we find comfort. And we say, well, there is nothing else. There's nothing else to actually explain, and there are very clear tests, and this is something which has been developed for a long time. But then I become afraid, and I always remember this line because I think it's something that tax lawyers and tax professionals should take into account, and that's the ruling in the Chevron case. And in the Chevron case, you have a judge, it's a billion dollar case, right? You have a judge who said, and I think tens of millions were spent on expert testimonies in that case, where the judge says, I have listened to the testimonies of transfer pricing economists, and they were not all economists, but he said it, and I found them in no correlation with the actual text of the statute, which I have to interpret. And if we don't have a clear link, I think we will be easily surprised that an inexperienced court would not be convinced. It would say, well, this is something different. Even though I think from a tax professional perspective, we will say, yes, absolutely, that's it. Where else to find guidance? But I think that if we look at jurisprudence, we might become surprised in the future.
I agree. I think the problem that we have is the fact that we have two competing forces. One is the fact that the BEPS project is a holistic project. The other dimension is the inclusive framework, which basically gives importance to that holistic project. So there is a natural tendency to look at transfer pricing, okay, when you deal with substance, or BEPS Section 5, let's say, because of this holistic approach. The problem is that the BEPS project has also basically made the arm's length principle a bit more fragile by stretching it too much. But at the same time, where do we find guidance? Because what the whole debate on the PPT is quite awkward to some extent, because what are we saying here? We're talking about substance. We're talking about business activity. So there is a paradox, because on the one hand, those states, the ones that predominantly prefer the PPT, are those states that do not want to go for a detailed LOB. So they reject the idea of the LOB, but the LOB is a test which achieves this, the mechanical and the certainty approach. I mean, it's very complicated, it's a bit a dummy test, but I mean, at least it's mechanical, and the US has always said, we like this test because GARs are too subjective, and we are not shrinks. We don't want to know what the intention of the taxpayer is. And now we're saying we have the PPT, but we would really like the PPT to look like an LOB. So I mean, it's
in this, and it's not. It started, I think, with Brazil. You have, and you'll hear similar explanations all over South America, and in this part of the world as well. When you think about channeling structures where let's say a Serbian resident will set up a holding company somewhere abroad. Now, very often people can tell you, I didn't do it for tax reasons at all. I did it for security reasons, because if I set up a company in Serbia directly, then my address is publicly available, and this is where my kids live. And I mean, if you look at Brazil, and now they're shipping children because of kidnappings, and I am afraid. So what I want to do, I want to put something in between myself and my personal address. So I would do this, I would go abroad without any tax reasons whatsoever. Now that I've taken the decision to immigrate effectively, now I take tax into consideration. So thus, tax has never been even one of the primary reasons why I did it. It's once I've decided, I'm a prudent person, so I will take tax into consideration. And this is just one of the examples where I think the primary reason argument becomes, and it's not as uncommon as one may think. This is a very, very common argument. Well, I don't want my address being publicly available. Now that I know I don't want this, I might think of a beneficial jurisdictions where I'm going to locate myself.
I think what is interesting, of course, is that when we look at the notion of substance, of course, it's one dimension when it comes to treaty abuse, one dimension to exclude treaty abuse. But you will see in the coming examples that we shouldn't look at substance or transfer pricing in a too rigid fashion, because you will see that then it clashes with other examples in the commentaries. This is a good time to go to conduit arrangements. I have 15 minutes, huh? Okay, good. Well, I think part of the problem in the commentaries is also the fact that several of the examples have basically been imported from different sources. So there are three types of sources that are, that led to this example. A very tiny amount of sources are in fact the example that the OECD developed itself. A second source is basically some of the examples have been actually driven by existing case law. And the third source is basically to copy-paste examples which have been already existing in treaty practice. And it is exactly what has been done with conduit arrangements. The OECD is saying, well, when it comes to conduit arrangements, the PPT will now apply to conduit arrangements. And how do we illustrate that application? Well, we are copy-pasting the examples in the 2001 United States, United Kingdom tax treaty. If you look at the clause of the US-UK treaty, it contains a conduit arrangement clause with a main purpose test. Now, if you look at the examples in the commentaries, I have listed them there, you see that all of these examples have been merely copied from the US-UK treaty with exactly the same outcome. Conduit, yes, no, no, no. So it's exactly, these are just copy-paste from the US-UK treaty in 2001. Now, one issue which is interesting in this example is, what is the interaction with these examples and beneficial ownership? Because, I mean, when you look at the examples, there are cases which are striking that they are being discussed at the PPT level, and the question that arises in the reader's mind, at least in my mind, is why has this issue not been already addressed by beneficial ownership? For example, the conduit arrangement clause, conduit arrangement examples, deals with a situation of a pure back-to-back loan. Okay, when you have a resident of a third state that assigns a claim to an intermediary company in a back-to-back scenario. So you have interest coming in and coming out. The commentary says, well, the PPT will apply. Treaty benefits must be denied. Remember, the PPT is Article 29.9. So if you go to 29.9, that means that you implicitly assumes that that company in a pure back-to-back scenario is the beneficial owner, because otherwise you would not need to go to 29.9. And this is very interesting because it means that implicitly the commentary is saying, well, the beneficial ownership is worth nothing. Well, the scope has been reduced, sure, but can you really say that in a pure back-to-back arrangement with mirror loans agreements, you would not have a legal obligation to pass on the income and you would not be denied beneficial ownership? I'm not sure. So there is a tension here between the beneficial ownership requirement and the PPT. And it seems that the PPT has absorbed everything that was previously covered by the beneficial ownership requirement. And nicely, from an academic perspective, but not necessarily from a business and realistic perspective, you can try, because academics always try to reconcile things, you can try to reconcile the beneficial ownership requirement and the PPT rule in somehow a dogmatic fashion as it currently stands. You could say, well, the beneficial ownership requirement will deal, in line with the 2014 commentary, with conduit situation in which there is a legal or contractual obligation to pass on the income, whereas the PPT will deal with other forms of conduit, the most frequent ones, the one in which there is a factual obligation to pass on the income, and for that the PPT will apply. But when you look at some of these examples in the commentary, it is debatable whether you really do not have a legal or contractual obligation. And remember, the OECD commentary, the 2014 commentary, says that the legal or contractual obligation may either be explicit or implied, that is, derived from the facts. So there is a tension there. And why is this tension relevant in practice? Is because in some jurisdictions, the beneficial ownership requirement is construed in an objective fashion without taking the attention of the taxpayer. You are or you are not the beneficial owner. Whereas the PPT, you build in this rational, this subjective element. And I think a good example to illustrate this problem and to come back to transfer pricing is example E of the OECD, the new OECD commentary, which I find quite enlightening in this respect. Enlightening, I don't know, but at least raising the problem. The situation is the following. You have a company in TCCO, in a third country, TCCO, that basically develops an intangible. Now, in accordance with the strategic practice of the group, once this intangible is being developed, it's being licensed to an entity in the state of residence, which is RCCO. Now, this entity then licenses the use of the intangible to a company in the state of source, SCCO. So the bottom line is that you have the state of source paying a royalty to the company in the state of residence, which essentially pays a significant equal amount with a very, 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 very tiny spread to the company in the third country. And the question is here, should treaty benefits be granted between S and RCCO? If you take a conceptual approach to beneficial ownership or an intuitive approach to beneficial ownership, you could say, well, I'm sorry, RCCO is not the beneficial owner. It is receiving 100 of royalties and is paying, let's say, 98 to a resident of a third country, so it's not the beneficial owner. That would be the approach we take in Switzerland, although in Switzerland we have a quite extensive approach to beneficial ownership. But still, you may also, even under the basis of a legal interpretation, you can really argue whether, is there really a, not a legal obligation to pass on the income? You don't know. The facts are not clear on that point. But let's assume it's not the case. But even on an economic approach, you could argue that, RCCO is not the beneficial owner because it's receiving a royalty and paying substantially all the same amount to a resident of a third state. If you take a transfer pricing approach, you say, well, this company basically it has a very, 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 very tiny spread, so it's not exercising any functions. I mean, it's not really doing a lot of work, because otherwise it would get more than a little spread. So, should treaty benefits be granted? So, the facts are quite not clear on that, but intuitively you might say, well, this is a back-to-back royalty structure. Why should we give treaty benefits? Well, at the time this example was discussed by the US and the UK in the 2001 the 2001 US-UK treaty. Now remember, the US-UK treaty contains a standard conduit arrangement clause. This conduit arrangement clause says, well, if a company receives the income and pays substantially all this income to a resident of a third state, it is a conduit. However, treaty benefits may still be granted if a main purpose test is satisfied. And what is quite interesting in this example is that the UK is saying, well, we recognize that the structure is a conduit arrangement. However, we will allow we should allow treaty benefits if we are the sole state, because the main purpose, or one of the main purpose of the transaction, was not obtaining the UK-US treaty benefit, so the structure would not constitute a conduit arrangement. So what the UK is saying in that example is basically, although there is a slightly little spread, although it's probably a back-to-back structure, although conceptually it's a conduit, because it has a business rationale, and because it forms part of the business rationale of the group, we will save the structure and will allow treaty benefits. Now the commentary on the PPT, under 29.9, says the same thing. Treaty benefits should be allowed. So when you look at this example, then you may wonder, well, what is the coherence with what we discussed earlier with having real risks, exercising real functions? What do you think about this? Coherent?
I think, coming back to the earlier point, would it be, I mean, if I look at the PPT rule and beneficial ownership, the question is, where do I put transfer pricing here? Because assume that ESCO is Serbia or Italy, for example.
Yeah.
I could claim that
Italy.
let's
Very
say,
good
let's take the
example.
Italian example. I would say, well, I would challenge the amount of the royalty rate based on the arm's length principle. And then I would look at the principal purpose test or beneficial ownership and say, can I grant a reduced tax treaty withholding tax rate based on the treaty between state S and state R? But I would apply transfer pricing up front to eventually challenge the abusiveness. So coming back to your first question, for me the first thing would be, let me see whether transfer pricing law allow me to protect the taxable basis in state S, and then I will discuss whether or not I can grant you the limited, let's say, withholding tax treaty rate here.
Okay, but let's assume we focus on the beneficial ownership requirement. Would you
Yes.
say that the entity is the beneficial owner in Italy?
In this case, I would tell you that Italy takes a very substantive approach to interpreting beneficial ownership. So I would say, well, if ERCO has no substance in terms of developing really the IP, I would claim that also ERCO is not the beneficial owner.
You see, so that's the thing. That's where we have a little bit of tension now, in the sense that, on the one hand, and your position in Italy is exactly the same that we would have in Switzerland, in the sense that we have not really endorsed the findings of the 2014 commentary. We are basically still stuck with a broad interpretation, economic interpretation of beneficial ownership. And if you look at the OECD here example, is, well, treaty benefits should be granted in the end. So this is, irrespective of the foundation, it's a big change for certain jurisdiction. In addition, the OECD is suggesting the fact that the company is the beneficial owner. So I think that what this shows is that there is, to ensure certainty of beneficial of the PPT, there is still additional consolidating work to be carried out between the various examples, because you cannot say that in one example that if you have real substance, real risks, if you have essentially genuine transfer pricing functions, you are actually fine. And then in another example saying, well, you have a back-to-back royalty structures, you're also fine because you're saved from a business rational point of view. There are probably grounds to look at the business rational, but I think the coherence between the examples, the relation between beneficial ownership should perhaps be further clarified. I use 5 more minutes. Just as I said, another area of uncertainty is cases in which there is no increase in tax treaty benefits. I think I mentioned that before. Suppose that you have a company in state R1 that is taxed at 25, at the corporate income tax rate of 25%. Now that company is basically interposing another company, another subsidiary in state R2, which on the other hand enjoys a lower corporate income tax rate, 12%. Now this interposed company enjoys, receives interest from the state of source. So the interests are received by the state of source, taxed at 12%, and then redistributed to the ultimate investors, which, because it's dividends, enjoys a participation exemption. So effectively, the scheme allows, a better treatment of interest payments, as opposed to the case in which the interest would have been directly received by R1, because the interest can be stored into the intermediary company or redistributed in the form of a dividend with a participation exemption. Now assume that all treaties provide for an equal treaty rate, so there is no increase in tax treaty benefit. Can the PPT rule challenge that structure? In my opinion, no, because we're talking about a domestic advantage. However, we've seen with the staff case that it's not so much about increase in tax treaty benefit that is relevant, it's also the relevant nexus with the state. So we've seen with the staff case that you do not necessarily need an increase in tax treaty benefits for the main purpose test to apply. This is another example which perhaps would need to be clarified in the framework of the tax certainty.
I have one question,
Yeah.
because this is very interesting what you've just stated, and because it draws on a very clear and I think an example which everyone in the room will recognize, and that's a situation where we interpose a Cypriot entity between a Serbian investment and whoever. Usually it's very often that it's a Serbian owner on the other side. Now, if we would take a look at the repatriation of profits in the form of a dividend, actually there would not be that much, there would not be a big tax saving, because there would be withholding on the distribution of the dividends when they are expatriated to Cyprus. Where the tax saving would occur is possibly in the case of capital gains. Now, we have a same entity, and in the case of one particular transaction, there is a tax saving. And in the case of another, again with the same entity, there's not a tax saving. So can we say that in one case we will deny the tax benefits, in the other we will grant them when it's good for us? Do you understand what I'm saying?
Yeah.
In one case, so if we would say, no, we shouldn't deny tax treaty benefits to you, then we would have a schizophrenic situation in which in one case it would be beneficial, in the other, with the same company, it would not. So how do we then take, because it's an arrangement which the PPT talks about. It's not the company, it's not the transaction, it's an arrangement. So how broad is that?
Yeah, I agree. But the question that you are actually asking is also the link between looking at the PPT as focusing only on tax treaty benefits or covering a broader spectrum. And I personally think we should not get into that scenario, because this is not the function of the PPT. The PPT is a GAR, but it's a treaty GAR. So the only thing that we have to look at is basically whether there is an increase in tax treaty benefits. The problem that we have is that one of the ancestors of the PPT, the Conduit Arrangement Clause that we had in the UK treaties, were saying, well, the PPT, the main purpose test of the UK treaty, was automatically switched off whenever the position was not improved, whenever there was not an increase in tax treaty benefit. In all other cases, no matter the rationale, the anti-avoidance provision was switched off. But because the PPT does not include that language, we're getting into that uncertainty. One last item that I would like to discuss for the finish with is the consequence of denial of treaty benefits. When you apply the PPT, you basically have a GAR, and if you have a GAR, you have to recharacterize the facts. The question is, if you recharacterize the facts, do you automatically grant the benefits that would have been available in the absence of the abusive arrangement. Take the case of a portfolio investors who basically would be entitled to a 15% residual tax. He contributes his shares to a company in order to take advantage of the qualifying holding limitation. This is seen abusive. The question is, can he automatically go back to status quo and have the 15%? In the MLI, there is a provision which is the discretionary relief provision, which is an optional clause, which allows states to go into that direction and upon request of the taxpayer to grant the benefits which would have been available in the absence of the abusive arrangement. Now, not all states have included that, have made use of this option. Switzerland, for example, did not because it thinks it's too burdensome, but interestingly enough, it also thinks that it will give the initial benefits automatically because this is just a consequence of the recharacterization of the facts. So my position is that even if you don't have this provision, it should not prevent a state from recharacterizing the facts and granting the benefits which are already would have been already available under the initial fact pattern. In other words, grant the treaty benefits which would not have been available, which would have been available in the absence of the abusive arrangement. Because otherwise, the PPT becomes a punitive tool, essentially. So I think that from a proportionality standpoint, this is the best approach. So I think I can save my conclusions and policy outlook for the Q&A discussion. I'm sorry I've exceeded a bit.
Thank you very much. We will now adjourn for a coffee break, which will last for 30 minutes.